I'm Drew Stevenson, and this is a lecture for my administrative law class about the case General Electric Company versus EPA, or the Environmental Protection Agency. This is a DC Circuit Court of Appeals case from 2002 about agency rulemaking and these agency documents that we call guidance documents. Now, for my students, please remember that the Administrative Procedure Act requires that agencies go through certain procedures to promulgate regulations. They either have to do formal rulemaking, which is very rare and requires trial-like proceedings and testimony and on the record and so forth, exhibits, or informal rulemaking, which isn't all that informal. It involves publishing a notice, a proposed rule in the Federal Register, having a public comment period, and then responding to the public comments in tandem with publishing a final rule in the Federal Register. So notice and comment rulemaking takes a long time and can be labor intensive for agencies. So sometimes when the agencies just want to clarify a certain point or get the regulated industry to kind of get on board with something, they'll put out a document like a guidance document that either interprets existing statutes and regulations or maybe tells them an announcement about enforcement policies, right? Basically gives some safe harbor provisions or guidance about how the agency will or won't enforce things. These generate a lot of litigation, right? Because usually the regulated party is saying, hey, wait a second, this looks like a rule. And so therefore you should have gone through notice and comment rulemaking, so you need to start all over again. And so that's what this case is really about. And I know it's not a US Supreme Court case, this isn't binding precedent, but it's a nice illustration of an kind of issue that keeps coming up in administrative law and is part of the practice of administrative law and that students should be familiar with. So let's look at what happened in this case. This is about a guidance document by a regulatory agency, the EPA, about proposals for cleaning up toxic waste sites, basically. And General Electric, or GE, is part of the regulated industry for purposes of this regulation and guidance. And the company says that this guidance document is functionally a regulation that should have gone through notice and comment rulemaking procedures, but didn't. Now, our statute, and remember, when in administrative law, always look at the statute, find the statute section being quoted in the case and so forth. The relevant statute is the Toxic Substances Control Act, commonly referred to as TSCA, which prohibits, among other things, making or using polychlorinated biphenyls, or PCBs, unless the EPA determines that the activity will not result in an unreasonable risk of injury to health or the environment. These PCBs, by the way, were widely used in making transistors for power lines and also in small electronic devices and appliances, and also on circuit boards like you might see in a computer or a device that has a circuit board in it, or transistors and so forth. And these are very toxic, and scientists estimate that half of the PCBs that ever left a factory, most of them were, the biggest manufacturer was Monsanto, are now in the environment, are polluting the water supply and the ground, and are a lot of wild animals have them in their system and so forth. And so pursuant to the statute, the EPA had promulgated rules for approved disposal and cleanup. So in places where PCBs had been dumped and there was a company that knew that they were partly responsible and had to help with the cleanup, or if they had barrels of this or scrap materials that were contaminated with PCBs, how they would have to dispose of those. So the regulations allowed parties to apply for permission to use alternative methods for safety testing and sampling and disposal and remediation. In other words, we have regulations that say, like if you have a site like this and you realize that you need to replace some of these gigantic um, capacitors and transformers and things like that, because they have PCBs, how you're supposed to do it. So you could just follow the regulations, but if you have an alternate method you want to use, usually because it would save a lot of money, that you think is also safe, then you can apply for special permission to use a different method than what's laid out in the regulations. And by the way, this chemical causes cancer. So the question that was left unanswered by this regulation that allowed parties to apply for special permission to do something other than the method specified in the regulation was how to assess the cancer risk for the proposed method of cleanup. So the EPA issued a guidance document with 2 approved methods of calculating cancer risk based on exposure. And by the way, they give the algorithms or calculations in the case. They're very technical. You don't have to remember them from my course. But they did this without rulemaking procedure. So basically there were 2 ways, and one, to oversimplify a little bit, was based on the amount of direct exposure that someone would have over time to PCBs, or how much exposure they would have to a lot of carcinogens, including PCBs, right? Because sometimes a site with a lot of contamination is contaminated with a lot of different pollutants. So GE said that these 2 risk calculations were effectively a new rule. The guidance document itself, though, said, quote, "The portion of the guidance at issue here is simply an expression of the EPA's policy judgment based on available scientific data and analysis that when the total toxicity analysis is used, the 4.0 microgram per kilogram per day, a -1 toxicity value is appropriate to avoid an unreasonable risk to health or the environment." In other words, they thought they were making a policy judgment that they thought that this was kind of announcing a safe harbor. If you just do this, as long as you find you are using this method of calculating risk exposure, then we'll give serious consideration to your alternate cleanup proposal. Now, note, if it is a rule, the agency really does need to do notice and comment rulemaking under the Administrative Procedure Act. And the court here, in this case, decided that the EPA guidance document was binding, essentially, because it believed the EPA would accept applications only if they conformed to one of these 2 risk assessment methods set forth in the guidance document. The EPA claimed or countered that the guidance documents lacked the force of law. They said it on its face didn't purport to be binding, and they hadn't applied it as though it were binding. And in fact, they said that it hadn't in practice applied it inflexibly as if it were a rule or regulation. In other words, they said, well, there could still be some leeway. We can still exercise discretion. So it's not a regulation. Like, we couldn't enforce this based on someone being out of compliance with our guidance document. We couldn't charge them with a violation of the guidance document. So therefore it doesn't have the force of law. So therefore we didn't have to do notice and comment rulemaking. The court still, even so, says that they're sure the EPA will not be open to considering approaches to risk assessment other than those in the prescribed in the document, at least when it comes to standard cases that the EPA does not think have components that require the use of a non-standard or unique or unconventional methods for estimating risk. And as an aside for my students, risk assessment is a complicated area of regulatory law, right? That there's there's controversy about this. If you've been through the COVID pandemic, that's why I'm recording this video at home, you know that there's a lot of debate and ongoing, like evolving understanding among experts and epidemiologists about transmission rates and exposure rates and what's safe and things like that, and what are adequate precautions, are how many people can be in a room before, and how close do you have to be, and so forth. And that's just for a germ, right, for a virus. And it can be even more complicated for a toxic chemical where it's in the environment and it's really hard to measure how much people are being exposed to it, or a minimal amount, the minimum amount of exposure that triggers cancer, and that's going to vary between individuals and so forth. So this is an area that generates a lot of controversy. We're almost done here. Here's a quote that I like from the case where they sort of lay out the rule. The ultimate focus of the inquiry is whether the agency action partakes of the fundamental characteristic of a regulation, i.e., that it has the force of law. And the court here in General Electric actually quotes an earlier DC Circuit case that's very famous and is in a lot of case books called it's the Molly Corp case, where they really laid out some rules or some analysis for distinguishing between what's a guidance document and what's really a shadow regulation or a de facto regulation. And remember, the agency is almost always going to be saying it's not a regulation because they don't want to bother with notice and comment rulemaking. And the regulated industry is almost always going to be saying that something that's just a policy statement is in fact really a regulation, and they shouldn't be able to enforce it or apply it without going through proper procedures. Here's another quote that I kind of liked from the case. If a document expresses a change in substantive law or policy that is not an interpretation which the agency intends to make binding or administers with binding effect, the agency may not rely upon the statutory exemption for policy statements, but must observe the APA's legislative rulemaking procedures. So, must a policy statement be non-binding on regulated parties in order to count as just a policy statement? And it seems like the answer is yes. That's where cases like this leave us. If the guidance document is binding on agency officials, decision makers, and adjudicators, that would imply it's also binding, at least indirectly, on the regulated parties, which makes it a rule that should go through APA rulemaking procedures. Now, let's back up a little bit and talk about this area of law and what's going on here. Courts have in effect defined rule as any agency statement that has general applicability. But note that under the Administrative Procedure Act in 553, that's the section that requires notice and comment for informal rulemaking, there are 5 categories of exemptions or types of agency statements that are accepted from this. And sometimes not only from that, but from other procedural requirements. Like there's another case in our casebook that's about the availability of judicial review. Now, of the different exceptions, the 5 exceptions in APA 553, to which basically is phrased as this section doesn't apply to these 5 things, and it's just a list. The one that generates the most litigation and confusion is these guidance documents. And some of these are interpretive rules about how they're going to interpret things, and some are policy statements that are sort of about either enforcement or when they're going to enforce and not, or when they're going to approve a proposal or not approve a proposal. And it matters whether a rule is a legislative rule, and you'll notice that if you read this case, it uses that phrase a lot, or merely an interpretive rule. The need for notice and comment turns on this. It also matters whether a rule is a legislative rule or a policy statement. That's the situation in General Electric versus EPA, because as the EPA claimed here, the need for notice and comment turns on this too. So note that it seems not to matter whether it's an interpretive rule or a policy statement, right? We don't treat those as any different. Either of those is not subject to notice and comment requirements. And so the EPA has I'm sorry, not the EPA, well, the EPA and other agencies have an incentive to characterize things as either just an interpretive rule, like this is a kind of a rule of thumb for how they're interpreting things, or an enforcement policy, or in this case, this particular case, an approval policy, and so that they don't have to do notice and comment. A true policy statement is a rule, a directive with general applicability that an agency issues. And so, and here's how we have an Attorney General's manual on the Administrative Procedure Act, and there's excerpts of it and quotes from it in your casebook. A true policy statement merely advises the public prospectively of the manner in which the agency proposes to exercise its discretion. Okay, that concludes our lecture about General Electric versus EPA.